Everyone, my name is Colleen Koch. I'm with Hutchinson Black & Cook here in Boulder. And on behalf of the civil litigation section of the Boulder County Bar Association, welcome to today's Civil Litigation and Alternative Dispute Resolution, CLE. Great, you got your case settled in mediation, or did you? We have a great panel of speakers lined up to present to you on the topic of the recent Colorado Court of Appeals case, Tuscany Custom Homes, LLC versus Westover, and its ramifications for us all moving forward. Our first panelist today is Rob Gunning, who I'm sure many of you are familiar with. He is a mediator with the Accord ADR group. Rob served for 6 years as the district court magistrate in Boulder, and prior to that served as an administrative law judge for the State Personnel Board. Rob also has many years of experience in civil litigation. In addition to his work as a mediator, Rob represents clients through his law firm Maxfield Gunning, LLP. Also joining us today is Doug McQuiston, who is a mediator with Accord ADR Group. Doug began practicing law in Denver in 1981 as a litigator, specializing in insurance coverage litigation, professional liability, nursing home and assisted living matters, and construction litigation. Doug is also actively involved in the Colorado, Denver, and Boulder County Bar Associations. Doug is now a full-time mediator with the Accord ADR Group. And lastly, my co-chair, Doug Stevens, will be presenting. Doug is a member of the Boulder firm Kaplan & Ernest, where he specializes in civil litigation, including construction, outdoor recreation, personal injury, commercial and contract disputes, and insurance bad faith coverage. In addition to his work as a litigator, Doug co-chairs the civil litigation section of the Boulder County Bar Association and has served as a mentor with the Colorado Bar Association's mentorship program since 2010. So thank you all for joining us today. I'm going to throw it over to you. Thank you.
Hey. Thanks, Colleen, and happy April Fool's Day to everybody. It's a somewhat inauspicious day to be presenting a CLE, and I'm glad to see there's no cat filters on our screens here today. So we want this presentation to be interactive. So at any time, if you have a question, please feel free to put a chat. And also, if you feel comfortable, feel free to unmute yourself and chime right in. We're going to start the presentation. I'm going to go through a summary of the case, some of the Dispute Resolution Act provisions that are at issue, and then we're going to turn it over to Doug McQuiston, or Doug Stevens for an attorney's perspective, and Doug McQuiston for mediator's perspective. And then we're going to hopefully have some time at the end for some hypotheticals and some scenarios. And we want this to be interactive, so please feel free to actively participate. So with that, I'll go ahead and start describing the case that's at issue here today. And it's the Tuscany Custom Homes versus Westover case. It's 2020 Court of Appeals 178. And we will be including a copy of the case with the materials today. And in this case, it was a published decision by the Court of Appeals on December the 31st of 2020. And we want to note that a cert petition was filed. A cert petition was filed on March the 10th of this year. Opposition brief was then filed, and the reply was just filed yesterday. So it'll be interesting to see if the Colorado Supreme Court accepts cert on this case. And I also want to note that none of the panelists here today were involved in the case in any way. So in terms of the facts of the case, Tuscany Custom Homes is a contractor, and they agreed to construct and sell a home to the Westover defendants, and that was John Westover and two limited liability companies of which he was a member. In turn, the Westover defendants agreed to sell the home to the Platniks. Tuscany then sued the Westover defendants for breach of contract, and the Westover defendants joined the Platniks as third-party defendants. Importantly, here, the parties went to mediation on March the 25th of 2019. So this was before the COVID pandemic, and it was in person. Towards the end of the mediation, the mediator intended to produce a settlement memorandum of understanding, but the mediator had some technical issues with his computer. So there was no, critically here, there was no signed memorandum of understanding, and the parties concluded the mediation without signing any document memorializing the agreement. Instead, the mediator returned to his office and sent counsel an email later that day. And I'll read the portion of the email that's reported in the opinion. It states, "Dear counsel, I would like to thank each of you and your respective clients for your hard work today in reaching a resolution. The purpose of this email is to summarize the terms of the settlement reached today, which summary will be used to prepare a formal mutual release and settlement agreement that is to be prepared by Tuscany's counsel. The terms of the settlement agreement are as follows." And the email then listed 7 payment terms, and the mediator wrote, "I request that all counsel review the above and email their assent to the above terms of the settlement." Tuscany and the Platniks counsel then responded over the next few days that the terms were correct with minor additions, and there was no word from the Westover defendants. Then on March 28th, which was 3 days after the mediation, Tuscany's counsel drafted and issued a draft settlement agreement. And Westover's counsel then responded, "We don't have any changes. Provided there's no red lines, we'll get our clients to sign." Thereafter, Tuscany and the Platniks signed this draft settlement agreement. However, the Westover defendants, the party, refused to sign the agreement. So when confronted with the party's refusal to sign, Tuscany filed a motion to enforce the settlement agreement in the underlying action, and the Platniks joined that. The motion alleged an oral agreement was reached in the mediation and attached the mediator's email and the draft settlement agreement as evidence of its terms. At that point, Westover denied there was an enforceable agreement and filed a proposed agreement that was identical to the draft agreement, except that it contained an additional paragraph which specified the agreement was not intended to preclude the Westover defendants from asserting future claims against non-parties. Tuscany and the Platniks then deposed the mediator, who testified that the parties reached settlement during the mediation. I want to note that many mediation agreements include a no subpoena clause, but apparently in this, the mediator, either there was not such an agreement in the mediation agreement and or the mediator agreed to be deposed. The district court, and this was pending in Larimer County, held a hearing. Westover objected to the admissibility of the mediator's deposition testimony, the mediator's email chain, and the draft agreement. The trial court provisionally admitted the evidence over the objection, pending review of the Colorado Supreme Court decision in Yaekov v. Andrews, and I'll discuss that in just a little bit. That's a 2008 Colorado Supreme Court decision. Following a review of that case, the trial court issued a written order and granted the motion, concluding that the mediator's email and the draft agreement were made to express and confirm already agreed upon terms, and that they did not contain confidential mediation communications. Relying on the admitted evidence, the court concluded there was an enforceable oral contract formed at the mediation, and the agreement was contained in the mediator's email. So now I want to turn to a few of the Dispute Resolution Act provisions here, and Doug's put those up on the screen. And the first here is the definition of a mediation communication. And this is excerpted here as noted. And it means any communication prepared or expressed for the purposes of or in the course of or pursuant to any mediation services proceeding or dispute resolution program proceeding, except that a written agreement to enter into a mediation service proceeding or dispute resolution proceeding, or a final written agreement reached as a result of a mediation service proceeding or dispute resolution proceeding, which has been fully executed is not a mediation communication unless otherwise agreed upon by the parties. So that's the definition of mediation communication. And then the next slide here sets forth Section 307 of the Dispute Resolution Act, or part of that, provides that mediation communications are confidential and inadmissible. Any mediation communication that is disclosed in violation of this section shall not be admitted into evidence in any judicial or administrative proceeding. That's subpart 3. And then importantly, the statute exempts from the confidentiality provisions any final written agreement reached as a result of a mediation service proceeding or dispute resolution proceeding, which has been fully executed. So those are the key terms of the Dispute Resolution Act that the court analyzed in this Westover case. And then the court also, before it got to the application of the law in this case, discussed the Yaekov v. Andrews case, which I alluded to earlier, and that's a Colorado Supreme Court decision from 2008. And that, as the Tuscany Homes Court here acknowledged, it really provides the seminal interpretation of the Dispute Resolution Act. And I'm not going to go into detail in that case because it is quite extensive, and we want to allow plenty of time here for hypothetical scenarios at the end. But in that case, the Colorado Supreme Court held that the parties can enter into a binding settlement agreement without a written or signed writing after the mediation. The court confirmed that the common law of contracts is not abrogated by the Dispute Resolution Act, and that there can be an enforceable mediation agreement without a signed writing. However, the court contrasted that with proving whether you have an agreement, and that was a case involving there was a partial agreement reached at the mediation that was signed initially by the parties, and then what followed were about 9 communications between the mediator and the parties, and the court analyzed each set and determined that some were admissible but some were not. And the court held that mediation communications are limited to those made in the presence or at the behest of the mediator. So that was the very quick summary of the Yaekov case, and we're also including that entire case in your materials as well, if you want to take a further look at that later. So then in this case, the court, in the Tuscany Homes case, the Court of Appeals then applied the Dispute Resolution Act and Yaekov to the facts at hand here. And first, as to the mediator's email, and this again was the email that the mediator sent out right after the mediation concluded, after the mediator got back to his office. And the court held that it was prepared pursuant to a mediation services proceeding, and that it was not fully executed. That a mediation communication includes memoranda of a mediator, and that's right out of the definition, the statutory definition of a mediation communication. And then the court concluded that the email that the mediator sent after the mediation was a confidential mediation communication. Next, the court looked at the draft agreement that was drafted by counsel for one of the parties and circulated 3 days after the mediation. And the court held that this draft agreement was also an inadmissible mediation communication because it was made at the mediator's behest, that the mediator was one of the recipients on the email chain. And the court also held that it was inadmissible even if it was not at the behest of the mediator. Court noted that Yaekov did not hold that communications made in the shadow of mediation are admissible to prove what happened during the mediation. And then court held in general the only admissible evidence of an agreement reached during mediation is a signed written agreement. And that's really one of the key takeaways for today, is that in general, the only admissible evidence is the signed written agreement. And the court did hold out, noted that there could be other ways to prove that, but it's a little bit unclear from the opinion how that can be done now. And then the Court of Appeals emphasized that the contract formation is not the same as proving that a contract exists. And then lastly, the court looked at the remaining evidence that was presented at the hearing that the trial court conducted, and determined that the remaining evidence, which was the deposition transcript of the mediator's deposition, the hearing testimony, which included testimony of several individuals, including Mr. Westover testified along with counsel for the Westover defendants because attorney-client privilege was waived. And then there was also the email correspondence that was transmitted by the parties after the mediator's initial email. Court determined that all of that remaining evidence was also a confidential mediation communication, and then there was not sufficient to support the district court's finding when the mediator's email and draft agreement were excised. So without the email that the mediator sent, without the draft agreement, which the court determined were confidential mediation communications, without those, the Court of Appeals determined that this remaining evidence was insufficient to support the district court's finding, and therefore that there was no enforceable settlement as a result of the mediation. So that's the Tuscany Homes case in a nutshell. And now I'll turn it over for perspectives, both from an attorney's perspective and from a mediator's perspective.
Well, thanks a lot, Rob. I think that was very thorough synopsis of the Tuscany case. And I'll tell you, the more I've read the Tuscany case, the more I've come away, and we've talked about it in preparing for today, with the conclusion that, gee, doesn't this case seem to run contrary to the stated purpose of ADR, the stated purpose of mediation? And as us litigators know, virtually every court in the state now has mandatory ADR. And doesn't a case that seems to make it more and more difficult to enforce a settlement that's reached at that very mediation run contrary to the stated intent? And it seems to us that it really does, because it kind of opens the door for, I mean, we all know how much time and money goes into mediation, writing confidential settlement statements, attending the mediation, preparing the client, and then you could spend all day at mediation and reach an agreement at the end of the day, and the door has now been opened pretty widely for an agreement that's reached at the end of the day to get undone if there's not a signed written settlement agreement. So I think that's kind of the 30,000-foot takeaway from all of this, which is a little disconcerting as a litigator. And that kind of segues into the first takeaway is that the settlement agreement needs to be written and signed at the end of the mediation, and should be hand signed or electronically signed by the parties and the attorneys, because I think it's questionable whether I know even the mediator in this Tuscany case, although it didn't become an issue because one of the parties never emailed or I should say the attorney never emailed their assent to the terms in the email that was sent by the mediator. The question becomes, even if that attorney had indicated his assent via an email, is that enough? Because it requires both 1320-802.5, which deals with the exception to mediation communication that you heard earlier, and then 1322-308, which is the statute that deals with enforcing a fully executed settlement agreement, requires it to be executed and to be executed by the parties. So with that being the case, would an email assent by an attorney sent the next day or even sent that day be sufficient And my sense is it probably would not be. I think what we need is it to be docu-signed, or when we all return to in-person mediations, being hand-signed by the attorney and the party, and certainly at least to the party at the end of the mediation, for it to be enforceable and not just an email assent. The next takeaway is that the settlement agreement, and I should also mention, for those folks that do insurance defense work, with respect to parties, I think there is a good argument that a signature by a claims representative for the insurer that has, authority under the policy to settle the case should be sufficient. But I don't know that that's ever been tested, certainly not under the confines of this statute, but I would think that would be enough, a signature from an insurance claims representative. Another takeaway is that the settlement agreement should contain all material terms and any non-monetary conditions. And so we're talking not just dollar amounts, time of payment, but also confidentiality and non-disparagement and other key conditions that oftentimes fall by the wayside in these MOUs or settlement agreements that get drafted and signed at the end of mediation. And I realize that could be tricky. Many times it's, we've all been in mediations that wrap up at 8, 9, 10 o'clock, and we have, our eyes are getting glossed over, and we just, we've reached an agreement on the dollar amounts, and okay, we'll deal with that other non-monetary stuff when we actually draft the release. Well, I think under this case, it's all the more important that you flesh that out, and you flesh it out as specifically and include material terms in that agreement. And that ideally should mean not just, well, we agree to non-disparagement, but what does that mean? Who's covered by that? Because I know I personally in the past year have dealt with that situation where we've been comfortable with the non-disparagement, but well, it's not realistic to bind every single employee of a certain company to that. We just don't have control over what they're going to say. So who's governed by that? All of the things that we typically deal with in a release, I think we should give some thought to during the course of the mediation and try to include that in the settlement agreement that's drafted at the end of the day. The next question and the next consideration is you want to think about how much you want to involve the mediator in post-mediation negotiations. And that happens all the time. We've all been in the scenario where we spend all day in the mediation and we don't quite get there. And then, the mediator says, well, I'll follow up next week. And sure enough, the mediator follows up and you have these subsequent discussions, and lo and behold, you reach a settlement. So I think with respect to that, first of all, oftentimes when that occurs, we don't have the mediator draft a settlement memorandum like we do. At least that's been my experience, like we do when you actually settle the case at the mediation. You just say, okay, I'll go ahead and I'll draft the settlement agreement. I'll draft the formal release now. I think under Tuscany, it's a good practice to have, when the mediator is involved in those post-mediation discussions, to have the mediator actually draft the settlement memorandum or the settlement agreement just as he or she would at the mediation, and all of the parties docu-sign it. Because again, as we've heard through Tuscany, if you reach that settlement and then someone gets cold feet the next day, or you can't agree on the actual details in the release, you're not going to have a settlement under Tuscany, at least under that Court of Appeals opinion. The court's not going to consider any of the evidence, certainly of the mediation communications, or even in the confirming settlement memorandum if it doesn't, or any email that's sent by the mediator if it doesn't actually get fully executed. And along those lines, I think it's important to consider whether you want the mediator involved in those post-mediation discussions. I typically find that it's very valuable to have the mediator involved, because he or she has the rapport with the other parties. They've been invested in the whole negotiating process, and it really helps to, just as mediation is valuable to have that mediator involved. So too, in a lot of post-mediation discussions, it's important. However, by involving the mediator, I think you're now covered by that privilege. If you don't involve the mediator and off you go, you're just negotiating with the other attorney, I think now you're likely no longer covered by the mediation confidentiality, and so you're just on your own. And now you can have, if you do reach an agreement during those informal discussions with the other party, you might be able to enforce a settlement that's reached with the other attorney outside the involvement of the mediator through common law contract principles under what's discussed in Yaekov. So that's something else to keep in mind. Another scenario that I've thought about is in your typical settlement agreement that's drafted and signed by the parties at the end of mediation. There's often that language that this is a binding and enforceable settlement agreement, and this may be presented to a court as evidence of a settlement, if not, if a formal release is not agreed to within 30 days. And so, you then have that large 1 month period to try to negotiate an agreement and formalize the release language. And I think it's worth considering when it may be advantageous now to essentially run out the clock. I think those situations are going to be few and far between, but if you have that settlement agreement and it's enforceable, and then you're talking after the fact, and you feel as if opposing counsel is adding terms that you'd never agree to, is that a tool that could be a valuable one to enforce the settlement, and just, we'll just go with that settlement agreement that we reached at the end of mediation. And then kind of part and parcel with what we did with the involvement of the mediator in post-settlement negotiations, I think we should also consider whether we want the mediator involved in the actual signing and negotiating of the release language. So let's say we've settled at the mediation, we have a signed agreement from the end of mediation. Now we're dealing with the actual release, and we're grappling over non-disparagement language or confidentiality language or some other term, the scope of the release. Do we want to involve the mediator if we reach a stalemate in that discussion? And I think the takeaway that I've kind of gleaned is, and again, this is with the backdrop that I typically always err on the side of involving the mediator, because I think the mediator's involvement is a valuable one. In light of Tuscany, I'm inclined to not involve the mediator in those discussions unless we very well have to, again, because it could then fall within the ambit of mediation communications. And I think if you don't involve the mediator, then you can present evidence of the draft settlement agreements going back and forth between the attorneys, and even present evidence of any oral agreements to the terms of the settlement. And that's ultimately what led to the settlement in Yaekov, where the one of the parties was kind of hemming and hawing about about whether there was a fully agreed to release at the end, and the Supreme Court hung its hat in part on the fact that the mediator was not involved in those communications at that point, and it was just in the shadow of mediation, and we had gotten to the point that it's really just typical back and forth communications that occur among attorneys. So I think those are all valuable takeaways to consider from an attorney's perspective in light of Tuscany and the Yaekov opinions. Doug, if you want to now take the baton and present your thoughts from the mediator's perspective.
All right. Yeah, thanks everybody, and thanks Doug and Rob. I always start mediation process when I do with the optimistic when we reach a settlement. I'll have language to that effect because I always want people thinking about getting a deal. I always make sure I tell them at the outset, when we get a settlement, I will write it up in shorthand form in a settlement memorandum, and the parties will all review and sign it, but that I don't stop the mediation process until I get it signed. That helps deal with some of the, issues of time and, gee, I've got to run. Can I just sign it tomorrow? Kind of things. I make sure people understand it's a rule because, as I say in this slide, it's a simple rule. The job's not over till the paperwork is done. I think if anything, the Tuscany Homes case makes clear that if you reach a settlement at mediation, you will sign a settlement agreement. Some sort of shorthand version, settlement memorandum, doesn't have to be the final release. But you do have to have the key terms, as Doug pointed out, the key material terms of the agreement, both monetary and non-monetary, pinned down. We've all had mediations, I'm sure, where the negotiation of the settlement agreement language after you've already reached a settlement agreement can sometimes take as long as the mediation. But it's an important step. And as we now know, the Tuscany Homes case says it's a mandatory step. So I make a rule to say no one leaves a mediation in which a settlement is reached unless we have a signed settlement agreement. And as we learned in the Tuscany Homes case, even if I have to write it on a big chief tablet with crayon, I'm going to do that and somehow scan it and send it to everybody so they can DocuSign that. There will be a document that they will sign come hell or high water. Saying, well, I'll send it around later just is not good enough anymore, if it ever was. So now that we're doing these by Zoom, I tell everyone the Zoom session will stay open and we'll all be logged in while we do the settlement and while we fully sign the document. Now, the nice thing about the technological advancements we have, DocuSign's actually quicker than doing it in person because it's asynchronous. Everyone can be doing it at the same time and it produces a signed document, I think, faster. So we will use that. What happens when you get into situations, as Doug mentioned, where a party may not be physically present? As it often happens with insured mediations, the claim handler is present and is participating, but the actual defendant is not. Is the claim handler's signature on the release or the settlement memorandum sufficient? Probably is. This particular case is silent to that, but I think the purpose of the Dispute Resolution Act is that there is a document signed by the parties, and if you treat parties as defined by the defense contract in a policy of insurance, the defendant turns over those decisions to his insurance company. So an insurance representative is probably good. What happens though in other types of cases where you might have a homeowners association, for example, where there might be any number of members of the homeowners association's executive committee, but a settlement is reached without all of them logged on. We'll want to pin down, I think, in terms of those mediations in advance, is the person who is here on behalf of a multi-member group like that authorized to sign in the event of a settlement agreement? And if they say they are, I think that's sufficient. But we have to be careful. We have to be, I think, mindful of that. That's another advantage to Zoom, is that we can get geographically varied clients in the process and get them all to sign. What happens, as Doug mentioned, what happens if a case just does not settle? This is slightly different than the Tuscany Homes case, where there was a settlement, it just wasn't written down. Then subsequent discussions are guided by the mediator. As Doug mentioned, often we do that, where we will continue the process of talking to the parties, carrying offers and demands back, guiding the process toward a deal, which is what we're paid to do. And then a settlement is reached. What do you do then? Historically, we would simply say, congratulations, you have a settlement. Here are kind of the broad terms, and send the parties on their way to negotiate a release and sign it, and that's all done. Since this case, I've been, maybe Rob can chime in as well, but I've been at least offering the parties a settlement memorandum. I will tell them, since this was not settled in mediation, but settled in subsequent discussions, if you'd like, I can write this up, circulate it via DocuSign, and have you all sign it, while you then go work out your release. And it's been well accepted. I'm starting to do that more and more now. And I think it just keeps the process cleaner, commits the parties to the settlement, and in the unlikely event they can't get a release agreed to, you have at least something to go to court with that I think would be admissible regardless of the Dispute Resolution Act confidentiality provisions. Because remember, settlement agreements signed by the parties are not confidential. So even if it's done after the mediation, I think it would come in. But as I mentioned in the slide here, I think it's important throughout to keep a resolution mindset in your heads and in your parties' heads. Sometimes we can become too much slave to the case law and lose track of what we're trying to do. The Tuscany Homes case is a complex case. I think it's something we have to obviously be mindful of. That's why we're doing a CLE on it. We have to keep in mind the purpose. As Doug mentioned, the Dispute Resolution Act and the court's general tendency to favor settlement should be kept top of mind. We want deals. We want these cases to get resolved. So if issues arise after the mediation, as they do in Tuscany Homes, I think it's wise for counsel to keep their clients focused on getting the resolution. You know, we invested a lot in the process of settlement. As Doug said, these are very costly and time-consuming procedures, and we want them to work. So I'm not privy to exactly what happened interpersonally in this Tuscany Homes case, but obviously things got sideways. So when those log jams arise, keep in mind that what you really want is a signed agreement. You want this case to be resolved and work through the log jams. We're here to help do that, but like Doug said, I think there may be cases in which you might consider not involving the mediator. But the counter position to that would be, as I said in the previous slide, would that approach change the outcome if the court applied this Westover Tuscany Homes theory of communications made in the shadow of a mediation? Is it the acid test that the mediator is involved in these? What happens if the mediator is not involved and parties do that thinking, well, we'll get around the Westover requirement and that will make our emails admissible? Will they or won't they? I think the overall thrust of the case, a pretty good argument could be made that that wouldn't necessarily change the outcome. In those situations, if a party, as they did in Westover, comes to court and says, we didn't reach this agreement, the parties might have a hard time enforcing even with the emails because of this shadow of the mediation requirement. So as Doug mentioned, I have kind of the same interpretation of this case. Every time I read it, and I've read it a lot since it came out, I come away wondering whether it fulfills or frustrates the purposes that courts have of fostering mediation, fostering alternative dispute resolution. It does make things more complicated, but if we follow the basic rule, it's not over till the paperwork's done. We can deal with it, I think, pretty effectively. With that, I guess we'll turn it over to any observations, questions, concerns people have. Some of the hypotheticals we were kicking around when we were preparing for this, we touched on briefly. What happens if all the parties are there? Everybody says, "Okay, fine, we're done. We all approve this settlement agreement," and the parties are all in the process of signing via DocuSign. But you have one party that says, "Oh, I got to run. I have a plane to catch. I'm watching my team on March Madness. My child has a piano recital, whatever. I'll sign it later tonight." Is that okay? I'm actually curious. Is that all right? Is that something that would I'll stop my screen share if I can. There we go. At least I'm trying to. There we go. What does everybody think? I mean, this is a good opportunity for everyone to unsilence themselves and chime in, because I'm not sure. I think obviously if the party signs it later while he's at his child's piano recital and whips out his phone and does it, sure, we've got a deal. But what if that doesn't happen? What do we think?
Doug, this is Brad Ramming. I mediated a case about a week ago, and a third of the parties headed back to Chicago, a third of them went back to LA, and the other two went to Dallas. And ever since then, they still have not signed my settlement memorandum. So I'm just periodically sending them emails saying, I hope you guys realize that until you get your signatures on this, you don't have a deal.
Yeah.
I don't know what else to do about that.
Right. I don't either. Once they're outside of, in your situation, outside of the confines of the mediation proceeding, what leverage does a mediator have, Brad, other than just that, saying you folks don't have an agreement because you haven't signed a document yet?
I mean, what I've considered doing, and I'd really be interested to hear what you and Rob have to say about this because you're both mediators, is I'm now well over a week past. I'm considering sending an email to everybody saying, this email is now outside the mediation. And I need to remind you that you do not have a deal, to see if maybe that scares somebody into doing something.
Uh-huh.
But I
Yeah,
don't know ethically what the mediator, I mean, I haven't been doing this as long as you and Rob have been doing it. I've only been doing it for a couple of years. I don't know ethically whether that's a smart move or not for a mediator.
Yeah, I don't either. Let's see what Rob has to say on that.
Yeah, I think if the way the court would interpret that would be, if you look back to the definition, the statutory definition of mediation communication, it's a communication made at the behest of the mediator, or from the case law language. So I think even if the mediator were saying this is no longer within the confines of the mediation, if it's an email from the mediator, I think a court, at least this court, will interpret that as being a mediation communication that's still confidential.
Sorry to interrupt. I think we're seeing someone's screen. Oh,
Right.
they took care of it. Thanks.
There we go.
And I think if I wonder if one of the attorneys for one of the parties sent such an email and said, and the mediator was not copied and said, I think this is outside the shadow of mediation. I wonder if that might help take it out and clarify where the line should be drawn. But that's a really good question.
My sort of knee-jerk reaction is I never, as a mediator, I always tell people I'm a slave to the deal. I will never, ever do anything other than promote an agreement. So I would be very hesitant as the mediator to tell everyone, okay, now we're outside of the scope of the mediation, but I'm going to say something anyway. You don't have, because really, notwithstanding the Tuscany Homes case, they do have a deal. They just haven't signed the document. And I'd be say you don't have an agreement for fear that some party who does have cold feet would use that now as evidence and subpoena me into court to testify that there was no agreement reached, when in fact there was. So it's a fine line. That's why I make it a bright rule in the mediations that no one signs off of this Zoom conference until I get a DocuSign agreement with everybody's signatures on it. Then I congratulate everybody and send them on their way. And if someone needs to sign asynchronously, I had a mediation last week where a party had to leave to go get their child and was leaving the office to go on something they couldn't delay. I said, fine, open up your phone and sign it when you're at a stoplight or when you're waiting for your child to come out of school. And they did. And we stayed on the mediation until they did. It was a few minutes later and they signed and all was well. So I try to be flexible, but I also make sure that, people will sign this before they leave. Brett Landis popped in a chat that from an attorney perspective, particularly in family law cases, what about scenarios where the client agreed in mediation, then refuses to sign or give authority to the attorney to sign an agreement that's sent out later? And that's a good question. If a party agrees to terms in a mediation, obviously the best practice is to write that up in the form of a settlement agreement, get them to sign right then and there. But I think under the Tuscany Homes case, if at any point a client decides not to sign, then there's no deal. Even if they said, yes, I agree to all this, and all the parties hear it. That's one of the things I also do when a case settles in mediation. I generally try to bring the parties back together in the same big room. Works better on Zoom so that no one can take a swing at each other. But I make sure they're in the same room and hear everyone say, yes, this is good. I approve this language. And then they sign. But Brett raises a good point. I think in that situation, you don't have a deal until something's signed. What do you think, Brett?
I agree. I mean, I think the client still has the right to back out before they sign something. And I think the court would probably, in a family law case where it involves like custody issues, would probably say that's important enough that the client's rights supersede. But I also see this being the most likely case where this is going to be really applicable, because that is where people are, I think, most likely to have buyer's remorse a few minutes after mediation, or where they're going to have something pressing on their time that means they really do need to leave. So unlike, the home building company that sends in their attorney and things are really, they have a little more leeway than, normal families who who are
I
splitting up.
think Brett is right. This will be a far more common scenario in family law, post-divorce, those kinds of mediations than I think it would be in the standard business mediation or personal injury mediation. Most of the time, those go uneventfully in terms of parties following up and agreeing to finalize terms, et cetera. But it does happen. I've had, like I said, I've had business mediations, construction law mediations, where the actual negotiation of the document has taken longer than the mediation, hours longer. And we still keep at it until we have something to sign. But it does, this will be an interesting thing to see how it develops as far as subsequent appeals, or whether it's taken up by the Supreme Court or the Supreme Court sees another case along this line. I think it would be helpful for the Supreme Court to take like Doug called it, a 30,000-foot view and decide as a policy matter more than a legal matter, do we want to favor settlements? Do we want to err on the side of saying there's a deal, as opposed to being too hyper-technical about construction of the DRA? Because we can get a little sideways with that. And Rob mentioned another point I think that bears mentioning. Many mediators include language in their mediation agreements that specifies the mediator cannot be subpoenaed to testify about anything. And I usually mention that to parties when they start. We have such a provision, and I say the process is confidential, and I cannot be called into court to testify about anything that's taking place during this mediation. That's my goal in life is to never be subpoenaed to testify, and so far so good. I don't want to be dragged into that situation, so I was kind of curious in this case how the mediator came to be to be deposed. It'd be the sort of thing that you'd have to put bamboo shoots under my fingernails before I would agree to. So it's kind of curious to see how that happened. I don't know how it happened. What other another settlement scenario that comes up, it happens a lot in federal court, where the magistrate conducts the settlement conference. Settlement conference results in a settlement, and the magistrate comes back out to court and says, I'm going to put this settlement on the record. And the judge recites the terms of the settlement and then has counsel step forward for the record to state their assent to the terms. Under the Colorado Dispute Resolution Act, is that sufficient? Parties haven't signed anything. Who knows? It obviously would have to be dealt with in the federal court, and the federal court hasn't yet pronounced on that. But technically, if this is a diversity law, diversity jurisdiction case, for example, and Colorado law applies, if the parties don't sign something, there's no deal, which is why, even in those scenarios, most of the magistrate-led mediations or settlement conferences I attended, they did have parties sign a document before the mediation was concluded. But it's an interesting question. And that Rob mentioned, or Doug mentioned, another question that comes up: how far away from the mediation do we have to be before we're out of its shadow and back in the sunlight where communications aren't confidential? As the mediator, I think we have a pretty big shadow. If the mediator is not involved, that shadow might be a little smaller. What does everybody else think?
I think with a lot of what struck me in both Yaekov and Tuscany Homes was that the court kind of drew a distinction about, like, well, in Tuscany Homes and in Yaekov, the court, the mediator encouraged the parties to go ahead and draft the formal settlement agreement, or basically said, I assume now that you're going to go ahead and draft the settlement agreement. And the court, like in Yaekov, when a month after after they had a signed settlement agreement at mediation, they were unable to agree to the terms of the formal release. Part of the Supreme Court's consideration with respect to the release negotiations a month later is that it was done at the behest of the mediator. So it was still, or of the mediation. So that was still not yet in the outside the confines of the mediation communications. I think it's a very much a gray area where it is, or where it becomes typical negotiations among counsel, as opposed to something that's still within the the mediation itself. I think part of it is, and what the court seemed to draw a distinction on is, did the mediator encourage parties to go ahead and put pen to paper and to start drafting? Because then you're having these conversations and you're drafting it at the behest of the mediator. So I think that's really where the distinction tends to be. So perhaps mediators need to be mindful of that and not encourage or somehow prompt the parties to actually go ahead and draft the release, but rather have language like, okay, you have a signed settlement agreement. It's up to you guys now how you want to take it from here. And in a way, Brad, that kind of ties into what you were discussing earlier. My sense is, even if you had that caveat that I'm not doing this in my role as a mediator, my sense is in Tuscany, the court would still say, no, this is still mediation communications because you're the mediator. Where I guess it could become interesting is if you then say to one of the attorneys, why don't you go ahead and kind of take it from here and, try to move things along with the other attorneys and finalize this. Well, is that, if one of the attorneys then says, hey, come on, let's figure this out now, or else we're not going to have a deal, is that going to be done at the behest of the mediator? Perhaps I'm getting hyper technical here, but it's, the court did take a pretty broad reading as to what was really happening at the behest of the mediator and what was, separate typical negotiations among counsel outside the ambit of mediation. So I think it's kind of the key distinction there is, are the parties truly acting on their own as opposed to at the prompting of the mediator?
One of those things where you have to keep in mind the purpose of involving the mediator, and you presumably would want the mediator involved to help guide the parties toward finalizing their agreement. And if that outweighs the slight risk that you might run into a Westover problem with mediator emails, go ahead and do it. It's ultimately, as I said, I think most cases that resolve in mediation or after mediation, the parties favor a deal, so they will work out these log jams. It's unusual for a case like this to come along. So we don't want to be too careful about involving a mediator, so careful that we end up not getting a deal. If we can help get the parties to a point where they resolve it, that help is probably worth it. But Doug's point is a good one. Our involvement may come with this potential Westover problem.
Doug, I'm curious, I presume, like many mediators I know, you probably had a paragraph in your settlement memorandums that said, once this is signed, it falls outside the confidentiality provisions. And I've since added another paragraph that says, this is not a mediation communication, and added some more language. I'm wondering if you've come up with any nice language that you've added into your memorandums as a result of this case.
Yeah, not yet. That's a good question. I don't know whether we should or not. Generally, our settlement agreements do contain language that this is admissible to prove, not only to prove a settlement, but this is an enforceable settlement agreement once everybody signs it. And we usually, our agreements to mediate talk briefly about mediation communications and say that the final document signed by the parties to commemorate a settlement is admissible to enforce the settlement. But yeah, what do you think, Rob? I think some maybe additional sentence in there could be in order that this document is not a confidential mediation communication.
Yeah, that's a good point. I think that would clarify it. I think under the statutory language, if it's executed by all of the parties, it may speak for itself as being not confidential, but I don't think there would be any harm in that, certainly in light of this case. And that's a good idea to clarify, and that everybody knows that it's the signed written agreement that's been executed by all the parties is admissible. And I think that this whole concept about the shadow of the mediation, I mean, it sounds like a good movie title to me, but I'm not so sure it's helpful to trying to assess where to draw the line in these cases. And it strikes me that if a mediator is on email chains after the mediation, well, that strikes me as a mediation communication, because it is at the behest of the mediator, and the mediator is actively involved along with oral communications with the parties or their attorneys. But the concept about one of the attorneys then drafting an agreement a few days later, and because the mediator may have suggested that was a good idea or even acknowledged that the attorneys were going to do that, is that also at the behest of the mediator? That to me, it is where it stretches the concept a little bit, and I'll be real interested to see if the Colorado Supreme Court takes this up. And I saw there was a chat question here from Steve Myrick that dovetails with this. Does this place the burden of drafting complete settlement documents at the mediation on the attorney or the mediator? Doug, what do you guys think?
I sure hope it's not on the mediator. But that is a good question. Do you then, do you just avoid the whole scenario by having a prepared full release ready to go and signed? I think the case seems to say specifically that if there is a settlement agreement, meaning that memorandum of agreement signed by the parties concluding the mediation, that's really all the mediator needs to do, even if the parties subsequently follow up with a full release. I usually put in my mediation settlement agreements that this agreement will be followed up by a more thorough release, which will be, prepared and executed by the parties. But in the event a release is not agreed to within 30 days, this is enforceable. But that is a good question. I have had mediations where one side or the other has come forward and said, I have a settlement agreement ready or a release ready. Do we want to go ahead and get it signed? And I've parked those in DocuSign and gotten signatures on them at the conclusion of a mediation. So sure, if it can be done, it's a good idea. To Doug's point, I think it's important that any monetary and non-monetary terms be spelled out, even in the settlement agreement. You don't want to run into that scenario where a party pops up later and says, oh, by the way, I want this clause that this doesn't affect subsequent negotiation or litigation against third parties. I always ask, and I'll remind parties, are there any other non-monetary conditions or any other conditions you can think of that you want in here? Because now's the time. But yeah, do you have to then, Stephen's question's a good one. Should we go ahead and get a full release? What does everybody think?
I kind of question the practicality of doing so.
Yeah.
Often with, especially with corporate type cases or where you have a lot of people that would need to, people that are attending the mediation have the authority to agree to the settlement and some of the key terms, but you get down to the nitty gritty and you need approval of people that aren't present, whether it's the school board or, folks that just aren't present. I think in a lot of cases, it's difficult to accomplish that. Plus, I think the logistical issues, I think it's, if it's a typical slip and fall case or something, and you can kind of estimate, it's just a matter of filling in dollar amounts. I think that's one thing, but I think it's hard to really foresee everything, even if you go in with a settlement agreement template, to really be prepared for that.
Stephen says in the chat that it seems like the best practice is to require exchange of draft settlement forms with material dollars and other sections with blanks. Could be the problem with blanks is that ends up giving another opportunity for the court to say, well, these things are blank. And if the parties don't fill them in later, do you really have a deal on any of this? How separable is your document? Then we get into that whole shadow of the mediation thing. It's like we almost get, when I read that phrase, I thought of Groundhog Day. If a mediator sees his shadow, you have 6 more weeks of litigation. The problem with using anything where there might be blank or counsel will put this in later, you run into the situation where you may not have an agreement if push comes to shove. So yeah, it gets complex, but like I said, we have to be careful not to let the sideshow take over the circus. In most cases, this can be dealt with very succinctly by a settlement agreement signed by the parties, and we're good to go. Subsequent things in the release may snafu things, but as Doug pointed out, if you have a signed settlement agreement and then someone disagrees with some specific language of a 10-page release, you can always just go to court and enforce the deal that's on the settlement agreement, and that's what you get. So the parties are motivated to agree on those subsequent terms, because otherwise they lose all leverage. They'll go to court and the court will say, oh, well, here's your settlement agreement, case closed. Any other questions, concerns? And I think we may not have heard the last of this. I don't know what will happen with this specific case, but I suspect there will be other appellate level cases, hopefully all the way up to the Supreme Court, that deal with some of the finer points of the DRA. And I certainly hope the Supreme Court states a bright line policy position that we will decide these cases with a view toward affirming settlements parties reach. So, we don't run into situations where, like this case, the Westover case, everyone seemed to agree, and then someone else kind of changed their mind.
Anyone else have any other thoughts or any other points they want to bring up?
No?
Good job, guys. Thank you for the presentation.
Thank you. Thanks for dialing in.
Yeah.
Yeah, thanks, everyone. I guess we're at the hour now, so I don't want to take up any more of anyone's time, but we really appreciate you joining in and for participating in this conversation with us.
Oops, I was going to share my screen, but I don't have it up. And in case anybody needs to reach us, Rob and I are very easy to reach at mediatelaw.com. It's just rob@mediatelaw.com, doug@mediatelaw.com. Feel free to get a hold of us. Thanks all for dialing in.
Yeah.
Goodbye now.
Thanks.
Bye, thanks.
Thank you, everyone. Have a good day.